It's part 4 of criminal procedures, starting with Sixth Amendment rights. Criminally accused have a right to a public trial, confront their accuser, be present at their own trial, and they have a right to counsel. And the right to counsel applies in any case the defendant is subject to potential incarceration. That's from Scott. It applies to all critical stages and automatically attaches when the state initiates prosecution with an indictment or formal charge. Examples of critical stages are confrontations which counsel would help the accused meeting their adversary. That's from Rothgary. This includes lineups, interrogations, arraignments, pleas, sentencing, the right to choice of counsel. If you're not indigent, you have the right to choose your own counsel. You have to pay for them. That's from Gonzalez-Lopez. Denial of counsel at trial, even denial of your chosen self-provided counsel, from Gonzalez-Lopez above. The conviction will be automatically reversed even without specific showing of unfairness. That's from Gideon. Now, for a guilty plea, if you plead guilty without your right to counsel, or without counsel present, you have a right to withdraw that plea, and plea cannot be used against the defendant moving forward. That's from White. Exclusionary rule in the poisonous fruits doctrine. Statements and physical evidence obtained in violation of the Sixth Amendment rights are inadmissible. This is from Nix. However, statements may be used to impeach. That's from Harvey. Standard of competence for counsel. Counsel must be reasonably competent. It's an objective standard, and this extends to your first appeal. Looking at lineups and photos, as far in the context of eyewitness identification, if it's pre-indictment, you have no right to counsel. So they just bring somebody in, you're not present, have them look at some photos, you don't have a right to counsel. That's from Kirby. If it's post-indictment, you have a right to counsel, and this right attaches only to any lineup that the defendant is required to participate in. Admissibility of pre- and post-indictment lineups and eyewitness identification. There is a two-pronged test. First, the defendant must demonstrate the procedure was impermissibly suggestive, and then the court determines whether there is a substantial likelihood of misidentification. That's from Biggers. For misidentification, you consider the witness's opportunity to view the crime, witness's degree of attention at that time, accuracy of witness's description prior to the identification, level of certainty, and length of time between the crime and the identification. Looking at eyewitness identification and appeal, if it's an illegal identification, the conviction is overturned unless harmless error, meaning it's not the determining factor, such as there's other evidence sufficient to convict. Examples of preliminary hearings, and this is not to say that the right to counsel attaches, but this is an example of preliminary hearings. There's a probable cause to detain. That's also known as a Gerstein hearing. Here there's no right to counsel because it's not adversarial. It's presumptively unreasonable if it's not within 48 hours of arrest. That's from McLaughlin. You have an initial appearance, an arraignment, where you're advised of charges and or rights. You enter a plea. Court sets bail and or release on bond and or assigns counsel. You also have a probable cause to prosecute hearing. Now, this is not held if a grand jury indictment brings you in. Here you have a right to counsel at a probable cause to prosecute if it is held. Looking at bail, you have no constitutional right to bail, but denial of bail must comply with due process. A refusal to grant you bail or granting of excessive bail is immediately appealable. Bail is excessive in relation, you must consider the amount reasonably calculated to ensure the defendant's present at trial. Anything in excess of that will be excessive. presumption in favor of pretrial release. However, there's a presumption against post-conviction release pending appeal. Looking at competence of the defendant. This is not insanity, but competence of the witness must be determined. The test is whether the defendant comprehends the nature of proceedings and has an ability to consult with the lawyer with rational degree of understanding, assist in their defense. The state's duty to disclose. The state must disclose material evidence favorable to the defendant and relevant to the prosecution's case in chief that would negate guilt and or diminish culpability or punishment. That's from Brady. Failure to disclose material evidence by the state is a violation of due process. There is a reversal if evidence favorable to the defendant and failure to disclose cause prejudice against D, meaning that a different outcome would have possibly occurred with the non-disclosed evidence. And that concludes Part 4 of Criminal Procedures.